This case starts off looking small, just a few dollars in dispute, but don't let that fool you. What you're about to see is a perfect example of how tiny financial disagreements can spiral into full-blown legal consequences. One tenant thinks he can challenge the numbers, but the judge? He's not here for technicalities, he's here for accountability. And in this courtroom, hesitation, confusion, or weak arguments can cost you everything. So the real question is, was this just a misunderstanding, or a costly mistake that could have been avoided?
$60047. Do you have did you guys, let me hear your names, please.
Captain Sadesky?
Your name?
Dylan there.
Has this been resolved?
Yes.
And what are the terms?
The terms are he's gonna pay $15.95 for January rent, $75 late fee.
Hang on one second. Okay, let me just. $15.95 for January rent, $75 late fee?
Yes.
Okay,
And then he's gonna pay the balance of the proration, which was $25.33.
okay,
And he had a missed water bill in December for $180.40.
okay,
And his final water bill was $110.70.
okay,
And he had 2 service calls for the heat and the garbage that was left out at the curb, which I have my contractor here that I sent over there for $80 service call twice, so $160.
Did you add all those up?
Yes,
What is the total?
I come up with $2,146.43.
Do you have a proposed consent judgment by chance? Is that what you're agreeing to, sir?
Yes, sir.
Is to pay $2146.43?
Yes, sir.
Jennifer, can you bring me a consent judgment, please?
Now pause right here. This is where things start getting serious. The court is laying out a detailed financial breakdown: rent, late fees, water bills, service calls, all stacking up quickly. And this is critical, because in eviction and tenancy cases, documentation and clarity are everything. If both parties agree to these numbers, it becomes legally binding through a consent judgment. But here's the thing: do you think the defendant fully understands what he's agreeing to? Or is he just trying to resolve things quickly without realizing the long-term consequences? Because once that signature hits the paper, there's no going back.
Fill it out for you guys when I get a minute. You can both read it, make sure you understand it. I'll hand it to you. You can both sign it. I'll call the case. We'll go from there, okay? Thank you. Ms. Sineski and Mr. Dillian, I'm checking the box here on the bottom. I'm just indicating defendant has vacated property. This is strictly for money damages, okay? So I've got inserted here 2146.43. If the two of you agree to it, sit down and read it. And that's it. And you've gone into the property and looked.
Yeah,
So everything else is in order.
yes.
So you guys can, but signed, put X where you need to sign the date. And let me come back to Mr. This is not a good deal. John, what happened with the?
Gina took those spot. You need me grab that?
I want to call this case with this young man here.
All good.
Mr. Ingram, are you ready?
I believe so, Your Honor. I do have.
Salters Realty versus Travis Hurst, 2601196. Mr. Hurst here, you guys?
Printing for plaintiff.
Don't go in. Is Travis Hurst here?
No, Your Honor, defendant did not appear.
You could take a default on this. Mr. Ingram?
Understood. This is a termination of tenancy matter, Your Honor. Given the fact that service was perfected, at this time, we would take a default possession judgment with a
Writ date April 16th, correct?
Correct, Judge.
You can submit your judgment. South Point versus Marquetta Brooks. Oh, wait a minute. I don't have that. What's your other ones, Mr. Ingram?
I've got the Brown cases. If you want to circle back to Rodriguez, I do have a representative
Brownstown
here.
Square versus Nelson Rodriguez, 2600939.
Brent Ticker for plaintiff.
Your name, sir?
Nelson J. Rodriguez, Your Honor.
All right, did you guys talk on this?
I tried to contact him, but he didn't answer.
Mr. Ingram, what is your position here?
Well, this is defendant's motion. He needs
I
to
know.
show just cause or meritorious defense, and I'm not sure that he's done either of those things. He did have some questions. I do have Mr. Ed Amati here to testify from the property if he would like to present those questions again in terms of, I believe, the balance that was owed.
I didn't have questions regarding the balance, sir. My question was, why would they claim that I owed rent from these?
Here we go. This is where the tension rises. The defendant starts challenging the numbers, pointing out inconsistencies in rent calculations and late fees. On the surface, it might sound reasonable, but legally, this is a risky move. Why? Because at this stage, the court isn't just looking at whether numbers are slightly off, it's asking a much bigger question. Do you have a valid legal defense? And arguing over minor discrepancies without strong evidence can actually weaken your position. So let me ask you, do you think he's exposing real errors, or just digging himself deeper?
Good morning to you.
Good morning.
Do I have Mr. Landau out there, Jennifer?
Judge, I don't know if he's.
As back as
Mr.
January
Rodriguez,
when that wasn't
right
done.
now, they
Yes, sir.
gave me a judgment for 12/29/79, it looks like. Let me double check. Yeah. And I signed that on March the 16th. I don't find any of your arguments persuasive so far, just to caution you. They perfected service. I don't know if you live there. I don't want to know, but you're responsible for taking care of the rent.
And
If
it
there's-
was brought up to date on March 2nd, which they continued to file paperwork. They had claimed that the rent was owed from as far back as January, which was not the case.
We have somebody here from Brownstown Square Apartments.
Yes,
Mr. Ed Amati is here, Judge.
yes.
What's your name, sir? Your name?
My name Human Etamadi.
Are you the manager of Brownstown Square?
Yes, one of the managers here at the property. Yes.
Well, you tell me what we have here. What he's saying, you guys didn't credit him properly.
Yeah, we have applied all the payments that he has paid so far. The amount what we had on the judgment was correct, and everything was applied properly.
Your Honor, if I may,
Yeah.
on the copy I obtained for their complaint, their original complaint, it says rent is paid through December 31st. That is incorrect. Rent had been paid through January 31st. It says the amount that was due was $1,050. That is also incorrect. It would have been $1,025. On your judgment that's the one I did receive. They said the rent amount is $900. That is incorrect. My rent amount is $975. Other monies due, they claimed $140. They never stated for what that was for. The only month
That was late fees.
the late fees that they include of the $975, they include a $50 late fee, which would have made it $1,025, not $1,040, which is what you get when you combine those two.
Wait a minute, they had court costs. How much did you think you owed in rent? They said 900 on here.
Well, I owed $975 plus the $50 late fee, and that was paid on March 2nd. They continued with this paperwork, even though I brought it up to date.
Judge, this is a rolling balance, and he owed at the time of the judgment. what he's quibbling over in terms of these numbers, I don't see that that speaks to just cause or meritorious defense. If he has some sort of ledger item, the time to go over that would have been at the hearing. But right now, we're just only issue as whether or not he's presenting just cause or meritorious defense in terms of his motion.
But if
That line from the judge, "You're talking nickels here," that's a turning point. What the judge is essentially saying is that these small differences in fees don't outweigh the bigger issue: unpaid rent and failure to appear properly. In legal terms, this comes down to material versus immaterial arguments. The defendant is focusing on small details, but the court is focused on the overall obligation. And this mismatch? It's dangerous. Because when your argument doesn't align with what the court considers important, your chances of winning drop fast.
if you are claiming that my rent was paid to December 31st on your original claimant, that is incorrect. That's false. My rent was paid up
There
to
may have been
February
payments
31st.
paid after that was filed, sir, but you had a balance.
No, sir.
on
No,
the day
look
of
at the
court.
date it was
Wait a
filed.
minute, Mr. Rodriguez. Wait, Mr. Ingram.
The only thing that matters is that he owed at the time of the judgment, which he did, and we stand by the numbers that we submitted to the court.
How much do you think you owed at the time that the judgment was entered on March 16th, Mr. Rodriguez?
Right now, I cannot tell you because I
didn't-
don't know
Whoa,
what month they're claiming.
whoa.
Oh, what I owe at the time of the judgment,
wait.
only the time.
Wait. I asked you, as of the date that I entered the judgment, March 16th of 26, what do you think you owed?
$1,025, which would have been the $975 rent plus a $50 late fee, only for the month of March, for that same month.
Well,
Now,
I don't
if
need
there's
to hear all
additional
that.
fees-
Hang on.
Sorry,
Just give me a straight answer. How much do you think you owe?
$1,025, and I don't know what fees they added after that they said.
Well, they added on other money due, which was late fees, and they added on court costs and statutory attorney fees. Actually, truth be told, I'm not sure you're not telling me in so many words that you owe more than this judgment's worth.
I wouldn't know because the 140, I don't know what that's for, Your Honor.
I said late fees.
Okay, so with the late fees, it's $975 plus 50 is $1,025. That includes the late fees.
They had two late fees of $70 apiece for a total of $140 is what they told me on March 16th.
Yeah, according to my lease, the late fees are $50.
Is that true, Mr. Ingram?
I would have to look. Mr. Edamati should be able to answer that, though.
Okay, the late fee is a $50 late fee and also a $15 late fee. It's $65 altogether.
Now this is where things get messy. We've got conflicting numbers: $50 late fees, $25 additions, claims of $140 total, and even the property manager seems to be clarifying on the spot. This kind of confusion can actually hurt both sides. But here's the key issue: the burden of clarity often falls on the tenant when challenging a claim. If you're disputing charges, you need solid proof, documents, receipts, timelines. Without that, it starts to sound like uncertainty rather than evidence. So what do you think? Was this poor record keeping, or just a weak defense?
Maybe that's where he's making making an error. But
You guys told me there were 140 in late fees. I don't know if it was 2 months, 3 months. I assumed it was 2. I could be wrong. Maybe it's parts of 3 months. I don't know. Can somebody tell me?
Here's a copy of my lease, $50 late fee.
it's
Nothing more on any of the pages.
okay. The first late fee is $50. The second late fee that is there is about $25. And that was added back in February 16th. So the total late fee, the $140, is accurate because you
Okay.
haven't paid for 2 months.
That is what I'm telling you is incorrect, sir.
All right,
When you
well,
filed this
hang
paper,
on, Mr. Rodriguez, you're talking nickels here. You really are. You didn't show up. We provided proper notice. And now you want to stop this. So I'm not going to do anything here. I'm denying your motion to set aside the default judgment. There is no good cause for failure to appear. And frankly, I don't see where you have a meritorious defense. So I am denying your motion to set aside. Actually, your motion is to stay the eviction.
And just like that, it's over. The judge denies the motion. No stay on eviction, no second chances. Why? Because legally, the defendant failed to show two critical things: good cause for missing court and a meritorious defense. Without those, the court has no reason to reverse or delay the judgment. This moment hits hard because it shows how unforgiving the system can be when procedures aren't followed. Missing a deadline or court date, even once, can completely shift the outcome against you.
that's all I need so that I can pay my rent.
Well, you
That's
should
what
have
I
thought
was
about,
asking them for.
stop. Don't start arguing with me or raising your voice with me.
Sorry, Your Honor.
Do you have today this judgment amount of $1,229.79?
I don't think so. I have it today, Your Honor, but I should have it by the end of the week.
Well, you only had until the 26th to come up with it of March.
When I spoke to them about paying it, they said if I don't pay it by then, I then would have to pay both months at the same time.
Well, I can't solve that for you.
I understand, Your Honor.
I'm sorry. You should have come up with the money when you were supposed to.
Your Honor, I wasn't 2 or 3 months late like they claim.
Sir, you're talking about pennies. Whether these late fees were supposed to be 100 or 140, I'm satisfied that they're charging you properly for late fees. I put caps on late fees, and that's that.
If I may, I'm not arguing the late fees, Your Honor. I'm arguing the
You can hear the frustration now. The defendant tries to explain, justify, even reason with the judge, but at this stage it's too late. Courts operate on structure, not emotion. And while his argument about timing might feel valid to him, the judge is focused on compliance and responsibility. This is a tough lesson. Being almost right isn't enough in court. You either meet the legal standard, or you don't. So ask yourself, if you were in his position, would you have handled it differently?
time.
Sure.
The
Sure.
time
I'm telling you, I'm denying your motion. You're going to have to talk to them or vacate. I'm not staying the eviction. I'm sorry. I wish you well. Thank you. Good luck. Kathleen Sineski versus Dylan Demmer,
Thank you, Your Honor.
26004. All right. Did you sign and read and understand this consent judgment for money for money damages only? Mr. Demmer?
Yes, sir.
Ms. Sineski?
Yes.
And you understand it amounts to 214643, sir?
Yes, sir.
And you agree to pay that?
Yes, sir.
And you understand that's for money damages overall, correct?
Yes.
And you vacated the property, correct?
Yes, sir.
You agree with that, right, Ms. Sineski? And did you sign and read and understand this document as well, Ms. Sineski? All right, so I'm going to order this money judgment here. I'm going to let you guys go down the hall and get your notice, and you're all set. I wish you well. Thank you.
Thank you.
All right, let's go back on, John, this seems to go down those two. Let's go back on Roger Allen LaBelle, 19F231-701. Mr. LaBelle, your name.
Roger Allen LaBelle.
Corporal, your name again?
Corporal Goldsmith, Flat Rock Police Department.
All right, what did you find out?
I can make the $200 payment. I have my mother and grandmother coming up here. It's going to be after my grandmother has cancer, so she's going in for a treatment today. She's going to come in around 3 p.m. and then my mom's going to come in and make the payment for me.
Okay. So
If that's
at 3
possible.
o'clock roughly?
Yeah, it'll be after the treatment. at
Where's Mr. Gaither
radio.
at? Mr. Gaither, are you out there? South Point Square versus Marquetta Brooks, 26019-01290. Ms. Brooks, your name, ma'am?
Marquita Brooks. Marquita Brooks.
All right, good morning to you.
Good morning.
Do I have Mr. Landau out there, Jennifer?
Judge, I don't know if he's. I'm looking through the breakout rooms to make sure he's not in one.
This case is a powerful reminder of how quickly small disputes can escalate into serious legal consequences. What started as a disagreement over rent and fees turned into a denied motion, a lost opportunity, and ultimately, an eviction moving forward. The judge made it clear, technical arguments won't save you if you fail to meet your obligations or show up prepared. In the end, it wasn't just about money, it was about timing, responsibility, and legal strategy. If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments. Who do you think was really in the wrong here? And don't forget to subscribe for more jaw-dropping courtroom breakdowns.